And they're trying to, I think, weasel in how they want you to comply with the rule that isn't actually necessary under the actual rule as written.
We are the Armed Attorneys. Today we are talking about one of the most frequently asked questions we're getting with regard to the ATF Final Rule on stabilizing braces. Now, this question has to do with the ultimate issue of, is removing the brace enough to comply with the law? But before we begin, show your support for the Second Amendment by hitting that like button. And I've gotten a lot of questions from I won't say questions, but statements from folks who are subscribed to this channel saying, hey, YouTube unsubscribed me. We went and checked our analytics on the back end. We see that almost 70% of our viewers are not subscribed. So if you are not subscribed, make sure to subscribe to the channel. If you have subscribed before, subscribe again because YouTube might have unsubscribed you.
Yep.
But we're talking about the question of compliance.
I don't want to deal with my Form 1, which I think is fair,
Yeah.
given that I think that there is to me, a better than not likelihood that this is struck down ultimately by the court system.
Yep.
But can I just remove the brace, not have constructive possession, right? Store them separately and wait and see what happens. And this is one of those things, and I don't know if it's pregnancy hormones or what, but it gets me really mad. I'm so angry about this, but we have very strong opinions about whether or not simple removal of the brace is enough to comply. And we have lots of internet lawyers who chime in and say, you can't just remove the brace. We actually have other lawyers in the YouTube space who we actually are friends with and talk to and practice with who have different opinions about this. But my opinion is very strong and I get really fired up about this issue.
Yeah, and that's the problem. I mean, you get two lawyers in a room, you get three opinions, you got two lawyers here. We have multiple opinions about things, but
well, I think we have the same opinion on this though.
Yeah, I think we do agree on this one.
Don't make me fight you about this.
No, but
okay.
All right. So, but here's the deal. What we look at is the modifications to the Code of Federal Regulation with regard to how we define a rifle, and then we look at the material that the ATF has published, and that goes to things that may have been printed in the Federal Register, maybe department responses to questions with regard to the final rule, and what, as far as we're concerned, what governs. Ultimately, at the end of the day, it's the Code of Federal Regulation.
It's just the modifications they made in the CFR. Nothing else matters. The ATF could tell you that the Second Amendment has been repealed on their website, and that doesn't make it true.
Right.
And essentially what we have here is, I think, the ATF probably anticipating that there's going to be mass noncompliance or anticipating a lot of hullabaloo. And they're trying to, I think, weasel in how they want you to comply with the rule that isn't actually necessary under the actual rule as written.
Yeah, and so we look at what the change in the final rule did was it modified the definition of rifle. And Emily, what is that definition?
Right. So our new CFR definition of rifle is, this is designed or redesigned, made or remade, and intended to be fired from the shoulder. Shall include a weapon that is equipped with an accessory component or other rearward attachment, e.g. a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder, provided other factors, as described in paragraph 2, indicate the weapon is designed, made, and intended to be fired from the shoulder. And in case you're wondering about what's in subsection 2, we're looking at different factors that would indicate there's sufficient surface area for the weapon to be fired from the shoulder. That are the things like weight and length consistent with a rifle, whether the weapon has a length of pull that is consistent with a rifle. We've talked about these before in previous videos. Whether the weapon is equipped with sights or a scope that can only be used when the weapon is shouldered. Whether there is, again, surface area created only by the buffer tube, receiver extension, or any other accessory component or rearward attachment that is necessary for the cycle of operations. That's our biggie. And finally, we have and you can see past videos on this rant, direct and indirect marketing and the use in the community are the other considerations there in defining what is in fact a rifle.
And so as you can see, we're talking about, the pistol itself, we're looking at the rearward attachment, and we're seeing, is that creating a surface area?
Right. And nothing in the rule as modified and as printed in the Code of Federal Regulations says, if your buffer tube can accept a stabilizing brace, it is an SBR. Nothing in that definition says that.
Yeah, and so this is the kind of crazy, I was thinking of an absurd hypothetical, and you look at what would look like an AR pistol, right? under the ATF's guidance, if you had your brace in a box sitting next to it, that gun would be considered a short-barreled rifle, according to their guidance. But if you had a smashed up brace inside of that box, that would somehow transform this into it would be a pistol. So I mean, we're talking about Schrodinger's AR, which that doesn't make any sense to me.
No.
And the rule in the Code of Federal Regulation looks at the rifle. It doesn't look at the things around it.
And then we have discrepancies in what the ATF is telling you in its responses to questions when they actually issued the rule, on its FAQs on the website. And it actually there talks about destroying or permanently altering your brace, which is interesting.
Yep.
Whereas the only feasible, and I use feasible in the most generous possible way because I don't think that there is a jury in the world who would actually agree that if you just had this one issue that Richard's about to talk about, that you would in fact be in possession of an SBR. But the only feasible argument I think the ATF even has, and Richard and I were talking about offline, and it's his notion. I thought it was very interesting.
Yeah, and that would be if the buffer tube or receiver extension, let's say it has some type of lip or railing so that a brace could be attached to it, and that, that's the part that it creates. If that is creating the surface area if that's creating surface area at the rear of the firearm, I think that's the argument that the ATF would make, theoretically.
Theoretically, right? If it expands that surface area,
Yep.
if it is then not just your standard 6 to 6.5 inch buffer tube or receiver extension, blah, 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 some of the things that we actually do care about based upon the new definition. However, there are other factors in the new definition that still weigh against that, such as if I put that thing to my shoulder without a brace on it and fire it, I'm going to have a bad day.
Right.
So, it really, there are, I would like to think that any reasonable, rational jury outside of, Washington, D.C. or, New York or I don't know.
Chicago.
I say that, but Matt Hoover had a Florida jury who you would assume would have done better. So, but you would hope that a rational jury would disagree with the ATF's characterization.
Yeah, and that's going to be the argument. Is this 1/32 of an inch sticking out from the receiver extension? Is that creating surface area
such that it's intended to be fired from the shoulder? And I think the answer is just no.
Yeah, I think that's what the argument is going to be made, but even that kind of sounds ridiculous.
But that's the argument. That is the only, and why Richard, I thought it was very interesting that he came up with this. Maybe he should be a government lawyer again.
Ooh, don't say that.
Just kidding. That is the only feasible argument. Beyond that, everything else you're seeing, everything else you're reading is all based upon the world the ATF would like to live in, not the world we're actually living in. So, too long didn't read. Can you simply remove the brace? Yes. My answer is firmly yes. If you disagree with me, I will fight you.
She'll fight you in the comment section. So make sure to leave a comment. And that's a question that we saw coming up over and over, or a term you'll see if you just control F any of these videos, you're going to see constructive possession or constructive intent. And what makes this different than, let's say, the bump stocks or the FRTs or anything like that is that part or combination of parts, that is a crime in and of itself.
Yes.
Those items are a crime in and of itself.
Correct.
Whereas there is a world, even in the ATF's mind, there is a world where an arm brace could be theoretically legal. This is a legal accessory because you could, manufacture a short-barreled rifle. They've already said that that's a legitimate short-barreled rifle. So the possession of a brace by itself, if that's the only thing you have, that wouldn't be a crime. Compare that to machine guns, which maybe, it would be a crime.
Right.
So, but we hope this settles a debate. We hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
Remember what Richard said, most of you are not subscribed. We would very much appreciate it if you would subscribe, and please question and comment for us below. Until next time, we're the Armed Attorneys.